to prove lack of integrity on the part of the first interested party. We affirm the finding by the trial judges that newspaper cuttings and various media printouts are insufficient evidence to discharge the burden of proof. We hold that without corroborating evidence, the probative value and weight of newspaper cuttings as items of evidence to prove a fact in issue is low. To this extent, the ground in cross-appeal that the learned judges failed to appreciate the contextual circumstances of the case in the appraisal of evidence has no merit. On burden of proof, the first respondent in ground 3 of its appeal holds the learned judges for fundamentally misapprehending the applicable law in finding that the burden of proof of apparent special relationship rests with the first respondent. It was submitted that in the contextual circumstances of this case, once the first respondent had demonstrated that a meeting had taken place between the President and one Majid Said Al-Ghurair, the evidentiary burden to prove that the said Majid Said Al-Ghurair, who met the President, was not a representative of the second respondent, shifted and rested upon the second respondent. That the evidentiary burden was upon the appellant and second respondent to prove that the tender for printing ballot papers was not discussed during the meeting between Mr. Said Majid Al-Ghurair and the President. That once evidence had been adduced that a awarded to the second respondent. Counsel submitted that these contextual circumstances raised reasonable suspicion that there was bias in the award of the tender, and the burden to disprove the suspicion rested upon the appellant and the second respondent. We have considered the first respondent's submission on legal and evidentiary burden of proof. The ground submission is the interplay between legal burden of proof, shifting or evidentiary burden of proof, and burden of fact, proving or disproving special relationship. The Supreme Court of Claims, Tirao Peter Munya versus Dixon Mwene Defendi, had occasion to illuminate how the legal and evidentiary burden of proof is applied in the law of evidence. In considering the application of the concept of shifting burden of proof, the Supreme Court expressed itself as follows. But Section 112 of the Evidence Act is not to be invoked without regard to the preceding sections, especially Section 107(1) and 2 of the same Act. In this appeal, the first respondent submitted that the learned judges erred and failed to appreciate the application of Section 115 of the Evidence Act. The submission by the first respondent that Section 115 of the Evidence Act applies to the facts of this case is misplaced. Section 115 applies to special relationships that exist in law and are covered by different substantive laws. For instance, the section applies to a partnership relationship or a landlord, tenant, or principal agent relationship, which are all covered by the distinct substantive laws. Section 115 should be applied a jus generis to incorporate special relationships such as director, shareholder of a company, or husband and wife. The facts of the instant case are not grounded on a special relationship governed by a distinct substantive law that can be construed a jus generis with other relationships envisioned under Section 115 of the Evidence Act. There is no alleged prior or pre-existing relationship between the President of the Republic of Kenya and the Dubai Chamber of Commerce delegation that is recognized by any substantive law. For this reason, the Section 115 of the Evidence Act is inapplicable to the facts of the case. In the case of Ali Mahdi Abdallah, the respondent claimed, in citing the case of Ali Abdallah Mohamed, the respondent claimed workman's compensation and alleged that the appellant was his employer. One main issue was whether the respondent was an employee or partner of the appellant. The respondent gave evidence that the former partnership had been dissolved. The appellant gave no evidence at all. The court held